A major development has just emerged from Washington, and it has serious implications for the Second Amendment. The Senate Parliamentarian has ruled that removing suppressors, short-barreled rifles, and short-barreled shotguns from the National Firearms Act cannot be done through the budget reconciliation process. This decision effectively blocks the latest effort to reduce federal restrictions on law-abiding gun owners without a full Senate vote. Supporters of the move argue it was a tax issue. Opponents claim it was regulatory. But the real question is, was this a matter of law or a calculated political maneuver dressed as procedure? The National Firearms Act, passed in 1934, imposed strict federal controls on items like suppressors, short-barreled rifles, and short-barreled shotguns. It introduced a $200 tax, registration, and fingerprinting, measures that have remained largely unchanged for nearly a century. Though framed as a revenue measure, the NFA has long been criticized for functioning as a backdoor form of gun regulation. For decades, gun rights advocates have argued that the law targets firearms rarely used in crime while placing excessive burdens on lawful owners. Recent efforts to delist these items aim to treat the NFA as a tax issue, until that path was shut down. The core of the current controversy rests on a legal question. Is the National Firearms Act primarily a tax law or a regulatory tool? The answer to that determines whether Congress can amend it using the budget reconciliation process, a streamlined method designed for fiscal legislation. In 1937, the Supreme Court ruled in United States v. Sonzinski that the NFA was a constitutional exercise of Congress's taxing power. The court acknowledged that the law had regulatory effects, but emphasized that its structure, a fixed monetary tax imposed on specific goods, fell within the scope of Article 1, Section 8 of the Constitution. That reasoning was echoed decades later in National Federation of Independent Business v. Sebelius, 2012, when the court upheld the Affordable Care Act's individual mandate as a tax. Chief Justice John Roberts cited the NFA as an example of how Congress can influence behavior through taxation without violating constitutional limits. The takeaway: a tax can be legal even if it's designed to deter conduct. This precedent formed the legal basis for proposals to delist suppressors, short-barreled rifles, and short-barreled shotguns from the NFA. Supporters argued that removing these items from the law simply eliminates a tax burden, something clearly related to federal revenue. Critics, however, claim the measure would do more than affect taxation. Their argument hinges on the Byrd Rule, which restricts what can be included in a reconciliation bill. Under that rule, a provision is disqualified if its budgetary impact is merely incidental to its policy effects. The Senate Parliamentarian agreed with that view, concluding that the broader implications, reduced oversight, changes in enforcement, loss of registration requirements, amounted to more than a revenue adjustment. This interpretation shifts the focus from the NFA's original tax structure to its downstream regulatory consequences. And that shift is what blocked the repeal effort. But it raises a serious constitutional tension. If Congress's only legitimate hook for creating the NFA was taxation, how can its non-tax features override the very budget process designed to amend it? The legal debate is far from settled. What's clear is that this ruling didn't happen in a vacuum. It followed decades of evolving case law and deep political undercurrents. The Senate's budget reconciliation process exists to pass fiscal legislation with a simple majority, avoiding the 60-vote threshold needed to break a filibuster. But it's tightly constrained by the Byrd Rule, named after the late Senator Robert Byrd, which prevents non-budgetary measures from being smuggled into budget bills. The rule says a provision is ineligible if its budgetary impact is merely incidental to its policy objective. In this case, the Senate Parliamentarian, the nonpartisan referee who interprets Senate rules, determined that removing suppressors, short-barreled rifles, and shotguns from the National Firearms Act doesn't meet the threshold for reconciliation. Why? According to reporting from The Reload, the parliamentarian reasoned that eliminating these items wouldn't just reduce federal tax revenue, it would alter the regulatory framework surrounding them. This includes lifting registration requirements, background checks, and fingerprinting. In her view, those consequences go beyond budget policy, making the proposal ineligible under reconciliation rules. Gun rights advocates argue the opposite, that the $200 NFA tax is not incidental but central. Millions of dollars in federal revenue are at stake, and the registration mechanisms only exist to enforce the tax, not the other way around. They contend that the tax is the legal foundation, and without it, the regulatory apparatus loses its constitutional footing. Here lies the tension. One side sees regulation as the main effect, making budget changes secondary. The other sees the regulation as merely a tool to enforce a tax, and thus subordinate to the financial component. Whether the parliamentarians' interpretation was legally sound or strategically motivated remains up for debate. But the result is clear. The attempt to delist items from the NFA via reconciliation is now procedurally blocked, at least in its current form. While the parliamentarians' ruling was presented as a procedural decision, many observers believe there's more beneath the surface. The timing, the framing, and the aftermath all suggest that political strategy, not just legal interpretation, played a role. According to a report from The Reload, the decision came just after midnight, shortly before a critical phase in the budget process. Not long after, Senator Jeff Merkley, a Democrat, announced that the NFA-related provision had been deemed in violation of the Byrd Rule. The suddenness of the announcement and lack of public deliberation raised eyebrows. Gun rights advocates weren't just frustrated by the ruling, they questioned whether Republican leadership allowed the proposal to be struck down deliberately. In a widely shared post on X, Sean Davis of The Federalist suggested that Senate GOP leaders used the parliamentarian as a foil. The theory, by letting her block the provision, they could avoid a politically sensitive vote while signaling to constituents that they tried. This kind of maneuvering isn't new in Washington. Lawmakers often use procedural rulings to deflect blame or shift responsibility. But in this case, the stakes are high. Delisting items from the NFA has long been a top priority for many in the gun rights community, especially after growing ATF backlogs and heightened scrutiny on firearms ownership. In response, organizations like Gun Owners of America and the Firearms Policy Coalition issued sharp rebukes. They warned that the decision undermines not just the reconciliation effort, but the broader credibility of those claiming to defend Second Amendment rights. If even a straightforward tax repeal can't get through reconciliation, they argue, what legislative path remains? Meanwhile, some in Congress floated fallback options. One idea is to reintroduce a stripped-down version of the proposal, removing the $200 tax while keeping registration intact. Another is to try again in a future budget cycle, hoping for more favorable parliamentary interpretation or a different political makeup. But these are half measures at best. Critics argue that keeping the registry while removing the tax leaves the constitutional justification for the entire scheme in limbo. After all, if Congress only has the power to tax, not to regulate firearms directly, then what authority supports mandatory fingerprinting and federal registration once the tax is gone? In the end, politics may matter as much as the law. This was more than a procedural loss. It was a strategic setback with long-term implications for gun policy in America. With the reconciliation path blocked, advocates for NFA reform are now regrouping. Though the immediate effort to delist suppressors and short-barreled firearms has been halted, it isn't the end of the road, just a change in direction. One fallback strategy gaining traction is to reintroduce a narrower version of the proposal that removes only the $200 tax while leaving the registration and fingerprinting requirements in place. This approach is seen as more likely to pass Byrd Rule scrutiny because it targets a clearly defined revenue stream without fundamentally altering regulatory enforcement. But critics see a problem. If Congress only has taxing power to justify the NFA, then stripping away the tax but leaving the registration structure untouched could undermine its constitutional basis. The registration was always meant to ensure tax compliance, not function independently. Without the tax, what legal authority remains? Another potential option is to revive the full repeal effort in a future budget cycle. Reconciliation bills are limited but recurring, usually one per fiscal year, so the idea could return under a new Congress or a different political climate. Some lawmakers have even discussed pursuing standalone legislation, though that would require 60 votes in the Senate, an unlikely outcome under current conditions. Outside of Congress, legal challenges remain a wildcard. Recent Supreme Court rulings, most notably Bruin in 2022, have shifted the legal landscape for firearms regulation. If courts continue to apply strict historical standards to Second Amendment cases, components of the NFA could face renewed scrutiny. Still, A direct challenge to the tax and registration structure is risky and slow, especially compared to legislative reform. In the meantime, the policy status quo remains. Suppressors, SBRs, and SBSs still fall under NFA regulation. Owners must still pay $200 per item, undergo fingerprinting, and register through the ATF, often waiting months for approval. According to recent ATF data, NFA application backlogs have surged in recent years, leaving law-abiding owners caught in bureaucratic limbo. What's clear is that the debate over the NFA is far from over. While the reconciliation effort may have hit a procedural wall, the legal and political battle surrounding it continues to evolve, and the next move could reshape the conversation once again. Beyond the immediate legislative roadblock, this moment raises deeper constitutional questions. At its core, the National Firearms Act rests on a narrow foundation: Congress's taxing power. It was never passed as a pure regulatory statute. That distinction matters. Supporters of the NFA argue that Congress has broad leeway to shape public policy through taxes. This view is rooted in long-standing precedent. Laws that deter smoking through cigarette taxes or limit alcohol use through excise duties have generally survived legal challenges. In that light, the NFA fits into a wider class of behavior-modifying tax schemes, but the Second Amendment complicates that logic. Unlike tobacco or alcohol, firearm ownership is tied to an explicit constitutional right. That means policies that burden access, whether directly or indirectly, must withstand heightened scrutiny. Critics argue that the NFA's combination of taxation, registration, and delay amounts to an infringement, not just a fiscal measure. Recent rulings have added weight to this concern. In New York State Rifle and Pistol Association versus Bruin, 2022, the Supreme Court held that any firearm regulation must align with the history and tradition of the Second Amendment. That framework leaves little room for modern schemes that rely on indirect restrictions, like waiting periods, license requirements, or taxes, as a substitute for outright bans. In that context, the parliamentarian's decision could set an uneasy precedent. If Congress can't adjust tax-based firearm laws through reconciliation because of their regulatory effects, it reinforces the idea that regulation, not taxation, is what's really driving policy. And if that's true, then future legal challenges may argue the entire structure exceeds constitutional boundaries. This isn't just a technical issue about Senate procedure. It touches on the balance of power between Congress and the courts, the scope of enumerated powers, and the limits of indirect regulation in a post-Bruin landscape. Whether through legislation or litigation, the questions raised here won't disappear, and how they're answered will shape the future of gun rights in America. The Senate Parliamentarian's ruling may have closed one legislative door, but it opened a much larger debate. The issue is more than a tax or a set of firearm accessories. It's about how power is exercised, how rights are protected, and how far procedural tools can reach in reshaping constitutional boundaries. The legal history is clear. The NFA is a tax. The political reality is less so. As the courts revisit Second Amendment doctrine and Congress continues its internal battles, this decision may prove to be a turning point, not just in gun policy, but in the limits of federal authority itself.